The South African Human Rights Commission will turn to the Constitutional Court to appeal a Supreme Court of Appeal judgment. The contested ruling states that the SAHRC recommendations are not binding and can only be enforced by a court of law. South African Human Rights Commissioner Tshepo Madlingozi joins us now for more on this conversation. Tshepo, thank you so much for your time this evening here in SABC News. I mean, you have turned to the Constitutional Court, to get clarity when it comes to the recommendations of the South African Human Rights Commission, whether they are binding or not.
We know that the South African Human Rights Commission is a Chapter 9 institution created to support democracy. We receive about 6,000 complaints a year. Now, once we receive a complaint, we investigate the complaint, we apply the law, we hear both sides, and we issue directives. And in most cases, complaints come to us on socio-economic issues. Now, the effect of this judgment is that on these 6,000 complaints, we will have to go to court every time we find that there's a violation. Now, that is impractical. That is not what the drafters of the Constitution intended. But most importantly, it will mean that people who come to us trying to enforce their right to water, electricity, healthcare, will wait for a long time before courts make a decision.
And I mean, Tshepo, one would say, this is very concerning. I mean, you are stating that you deal with a number of cases, and it really is quite a stretch to take every single case you have, to a court of law.
Absolutely. You will know that, access to justice is a problem in South Africa. We've got a constitution, we've got good legislation, but the ability of millions and millions of South Africans to vindicate their rights to go to court is very, very difficult because people cannot afford lawyers. So they come to a Chapter 9 institution that is empowered by the Constitution, by our Act, to vindicate their rights. And if, if respondents can ignore our decisions and recommendations at a whim, that will put the legitimacy of not only the South African Human Rights Commission into peril, but the whole constitutional order.
And, when it comes to the ruling that we saw from the Supreme Court of Appeal, and one would say, what does it say about the prioritization of human rights in this country? I mean, you also talk about court. Let's also talk about the fact that court already has, a number of years of a backlog. So if you are faced with that issue, what does it say about, the prioritization here when it comes, to the rights of South Africans?
Well, the first point to make is that, South Africa, emerging out of more than 350 years of colonialism and apartheid, one of the, countries with the highest Gini coefficient, meaning that, the most unequal country in the world, the scale of GBV and so forth. The scale of the problem is so vast that human rights should be prioritized. And you are quite right, millions of South Africans who are just trying to vindicate the rights that are there in the Constitution will have to, find themselves in a situation where they have nowhere to turn to. As you say, courts themselves are overwhelmed. It takes a long time, number one, to get your matter to court. Number two, it takes long for courts to make decisions because courts also take a long time to hear both sides and so forth, to write judgments and so forth. People can appeal. So it takes a long time. We already have a culture of impunity in South Africa where, even decisions of courts are not well respected. So if we are to burden the courts with this issue, it will be impractical. And it will once again put us in a situation where people say, what is this Constitution for? What are these Chapter 9 institutions for? So we are very, very concerned about this decision.
And I mean, we're speaking about that exactly, this Chapter 9 institution. If its recommendations are not binding, then what is the point of having the South African Human Rights Commission?
Absolutely. The drafters of the Constitution created Chapter 9 institution as part of an ecosystem with the courts, NGOs, and other bodies to, be a vehicle for quick access to justice, to hold the state accountable, to be an oversight body over, the executive and so forth. And therefore, the effect of this decision, if we say that, number one, anyone can ignore the decisions of the Human Rights Commission at their whim, it will mean that if this constitutional body becomes a glorified, NGO, it becomes a toothless dog, and that will have serious consequences in, as I said, a situation where we are already having people saying, what has the Constitution done for me? We are doing our best. We receive about 6,000 complaints, as I said, and people turn to us because they believe that when they come to us, we'll investigate their matter fairly, we'll hear both sides, we'll apply the law, and we'll secure redress for them.
And when it comes to this court matter, when can we expect for this matter to be heard by the courts? And then what happens to those who have cases right now before the Human Rights Commission when it comes to the sort of recourse that they need from the Human Rights Commission? It puts it in jeopardy.
Well, we launched our appeal on Thursday. The Constitutional Court will, look at our papers and decide whether the appeal should be heard. We think we've got good prospects of success before the Constitutional Court. So it will take months, for the court to come back to us, for the matter to be enrolled, and for the hearing to commence. In the meantime, we have told our provincial managers, we've told our human rights monitors to continue doing their work as normal. We continue to receive cases. We continue to, conduct hearings and inquiries, and we continue to give directives. The Supreme Court of Appeal even itself says our decision cannot just be ignored. But the problem is that what the court does is to put doubt in the minds of those who are intent on violating human rights, to say, the Supreme Court of Appeal said we can ignore you, and therefore we're not going to listen to you. Well, because the matter is on appeal, the status quo remains, which is that our directives cannot be ignored. Those who are unhappy with our directives should go to court and take us on review.
And when it becomes heard in the Constitutional Court, what can we expect from your arguments as the Human Rights Commission?
Well, firstly, we are arguing that our Section 184 of the Constitution must be interpreted purposefully. Of course, you won't find the word binding in the Constitution. It's the same as with the public protector, you won't find the word binding. But if you interpret the section like, it happened with the public protector's case, you'll find that the purpose of creating these institutions was to create powerful institutions which will hold the state accountable and which will secure redress for victims of human rights violations. Number two, therefore, we argue that there's no hierarchy that was intended, with Chapter 9 institutions. You cannot say one Chapter 9 institution is more powerful than other Chapter 9 institutions. Thirdly, we are saying that the effect of this decision is to reverse the burden. It says that when we found that a respondent has violated human rights, we ourselves must go to court every time to enforce our decision, not the respondents who must go to court. So it reverses the burden of proof. But number four, we, argue very, very strongly that saying that, every time we find a violation, we must go to court, it will mean that people who rely on us for vindication of their right to water, their right to healthcare, will have to wait a long time for justice to be done to them. And as you know, justice delayed will be justice denied.
All right, Tshepo, thank you so much for your time this evening.